to episode 14 of Coffee with Casey. Today we will be discussing compliance and action. And I'm very happy to welcome our guest today, Eileen Bitterman, our compliance director here at the firm. Good morning, Eileen.
Good morning, Casey. Good morning, audience.
And just a few quick housekeeping items before we get started. As a reminder to our return audience members, this is an interactive webinar, so please feel free to type your questions into the chat feature as we're going through the presentation. We will answer all questions as we can if time is available, and if we are not able to answer your questions live on air today, we'll be in touch after the webinar. Also, there'll be a brief survey sent to you. It'll pop up on your screen after the webinar. Please give any and all feedback that you would like to share with us, and any future topics that you would like to see us chat about on Coffee with Casey. With that, just a little bit about Eileen. Eileen was born and raised in Cleveland, Ohio. And Eileen attended the University of Dayton for her undergrad and Cleveland State University for law school. Eileen's in her 31st year with the firm. Yay! She began as our personnel director, and also she was our first female partner elected to the firm's management committee. So congratulations, Eileen.
Thank you.
Eileen's focus today at Weltman is on compliance, client services, client audit, and onboarding. Outside of that, Eileen likes to travel, go to live theater, and she likes Cleveland sports, which is a surprise to some people. And with that, we have our first poll of the day. So who out there is drinking coffee or tea? And Eileen, what are you drinking today?
Okay, well, I can tell you I am drinking coffee. My Irish background had me growing up with tea, but I will tell you that when I was working full-time actually here at Weltman in personnel and going to law school at night, I found my love of coffee. So I am drinking black coffee today, but I will tell you I drink coffee that is infused with a flavor. So there's a local grocery store here called Heinen's, and I'm drinking caramel nut fudge black coffee. So it's not a syrup, but the bean is infused with a flavor. So
that sounds delicious.
It's quite good. I have to say, I do share it with staff here. We actually have, a coffee maker. The world of the pod has, come upon us. It's not the pot of coffee that you start at 9 a.m. and drink till 5 p.m. any longer. You can kind of make a fresh cup anytime you want. So the pods are really very beneficial. So the caramel nut fudge is a big hit here, and I'm enjoying that today. So cheers to you guys. What are you drinking, Casey?
I have a pod coffee today. I was in a rush, so I have black pod coffee today.
Perfect.
And it looks like our poll results 89% coffee drinkers out there today. So hope everyone enjoys their coffee. And today's, briefly, I'll go over our topics for today before I kick it over to Eileen. So we've got 3 key topics today. We're going to do an overview of the CFPB debt collection rule, known as Reg F. We're going to review compliance management systems and their importance for organizations, and review why compliance is everyone's responsibility. So with that, Eileen, I'll let you get us started.
Great. And I'm going to keep you right here on this title page for just a second, because before I go into the full topic of the CFPB rule, I want to talk about the CFPB first, right? So Dodd-Frank brought us the CFPB in 2010, 2011. It became official for guidance for us. I will say that Weltman is a large market participant, and we are also a vendor financial institutions, which means we are subject to the CFPB. Now, I know there's been a lot going on with the CFPB, and even since their beginning with us, when they were doing, supervision and enforcement, and then of course the rule comes along, we've heard everything about the fact that they were unconstitutional or they shouldn't be funded. We've had 4 or 5 different directors, acting directors during my time here, different members of the White House. But I tell everyone here at the firm, here, I want to keep our doors open. So as long as the CFPB's doors are open, we need to adhere to it. So the CFPB rule that I'm going to talk about today is in place. It continues to be in place. The CFPB portal, where consumers can go and log a complaint. Doesn't necessarily mean the complaint has valid. It could be baseless at times. It's just their way of communicating. But if they go and log that complaint, we still have to address it. So until they actually close their doors, I always tell people, with all the things people are hearing in the news, you know, how does that impact you? What are you going to do different? We're not doing anything different, because right now, the guidance that we've gotten from the CFPB, as you're going to learn a little bit about today, is actually beneficial to us. There's a lot of best practices from it. We've had it implemented. We're going to talk about the fact that it's coming up on its 5-year anniversary in November from when the rule implemented, and how that's changed us a little bit. So we're going to talk about the fact that the CFPB for us is here to stay. We're going to stay in compliance with it, and we help to guide our clients and our vendors, as well as consumers, through that path as well. So if you'll go to the next slide for me. Just a little history, as I was starting to mention earlier. Of course, the CFPB has been around for a little while, but the rule, the fact that they could do a rule that we have to be responsive to and we have to follow, that was done in 2 parts in 2020, and then the entire rule was effective November 2021. So coming this November, it'll be 5 years. The first part was really focused on communication between the debt collector and consumers and the new technology available to give guidance. And part 2 was really focused on the MVN, what we call the model validation notice. It basically replaced the initial demand letter. But I'd like to remind people that Reg F basically restated fair debt. And the Fair Debt Collection Practices Act has been around since 1977. So we've been following it quite well for many years. So when it restated it, it added some clarifications. It provided some safe harbors that we're going to talk about today that are very useful to our firm and the industry. And it addressed some new technologies. So we felt that we were already in a lot of compliance when the rule came along, but we did have to make some adjustments that you'll hear about in terms of our processes and procedures and working with our clients. So the implementation, as I mentioned, the industry was focused on to make sure that there were some prohibitions about communications, that they were expressing things they didn't want to happen, and giving opportunities, though, to enhance those communications with new technology. We, as an industry, continue to review and audit our policies and procedures and training materials so that we're doing sort of a gap analysis to see if there's anything new or that needs to be updated so that you always have best practices. We really had to engage a lot of third-party vendors to partner with us, obviously for the functionality and the operation, which was essential. So when some of the new parts came out about, which we're going to talk about, you know, the frequency of calls and the information and data that had to be on MVN, you really had to work with your vendors for your computer systems as well as your clients for getting that data. And working with those client creditors has been essential to us. Having that data available to actually have the MVN be accurate and populated properly, being able to get the media that we need, the documentation to support disputes and things of that nature, and also the backup for the concept of using new technology, which we'll get into about the emails and texting. So we continue to develop audit tools as we go to track any new procedures or new communication formats that are going to be implemented, and it has been implemented over time. We didn't actually just, you know, immediately start using texting and email 5 years ago. It's been sort of a slow growth pattern to make sure that we're focusing on how to do it and how to do it correctly. Next slide, please. General guidance reminders. It applies to consumer collections, not commercial specifically. The rule also sort of extended some definitions for us. There was case law out there about decedents and the deceased consumer and how that was supposed to be treated under fair debt. Now the rule explicitly states that a consumer does include a deceased consumer, so probate collections are very focused on in that. An attempt to communicate was the concept that they came up with for the voicemail issues that were happening in our industry. So we now know that a voicemail is not a communication, it's an attempt to communicate, and there's some safe harbors to it that we'll talk about. So the rule doesn't apply to first-party creditors, but our creditors are essential to us, the third-party debt collector, actually getting into compliance because we need their data, we need their information, we need to partner with them to make sure that we are doing what's proper under the rule. But I always tell people the rules guidance can be incorporated into any collection center for best practices. whether it's commercial, whether it's first-party collections. Obviously, the rule has some great common sense approaches to debt collections to make it beneficial and resolutionary, which is the whole point, right? You're trying to get to a resolution with that consumer in a way that's proper and appropriate and provides courtesy to them and respect to one another without there being any concerns or anxiety or issues, which is the whole point of fair debt and the rule, right? To make sure that there's no abuse or harassment, but that the resolution process is one that benefits everybody. Now, I will bring up the point here that the rule is great, but you need to always remember that a client can also have rules, right? And client work standards are a part of our compliance management systems as well, because they could be stricter than the rule. Easiest example is things like texting, right? We have some clients that just don't want us to text. So even though it's allowed under the rule and we can legally advise them how it can be done and why it should be done and why they might want to consider it for the future, we always have to respect our clients' standards and how they want their portfolios to be treated. So if they choose not to be doing texting, even though it might be legal, you could have an audit finding if you're doing it improperly for a particular client. So that's important to know. And then, as I've mentioned a couple times already, that client data and communication for documentation to get to us and to communicate with that consumer is critical for our compliance under the rule. Next slide. So let's go to some of the highlights in the last 5 years. What have we seen that's really changed? What has the rule brought to our industry? The communication methods, right? That was the big focus of this rule. Back in the day, there was a ton of litigation about voicemails. Was it a communication? Was it not? Did you need to leave the mini Miranda disclosure or not in case a third party heard it? So the rule came back and said, okay, guess what? We're going to give you some content, a limited content message that if you follow this rule, this safe harbor, and put it out on a voicemail, exactly as we say, there are requirements in it. It's very limited. There's a few, optional things like good morning and hello and things of that nature that you can add to it. But the limited content message must be followed for you to get the safe harbor. I understand that sometimes people want to add more to the voicemail, but once this rule went into effect, we felt we wanted to take advantage of it. So we do use the limited content message. And I'm very happy to say over the last several years, we have not had a lawsuit on a voicemail. And that was a big issue in our industry. It still allows you to leave a decent voicemail with our phone number and the person who's calling to be contacted back so that you can start the collection process. That's the point. It's an invitation to communicate. It's not meant to do anything else. So by following that safe harbor, that's a really good thing. I will point out that you can do something different and still be in compliance, right? So if you want to try a different voicemail, you can. But the reality is the consumer bar could then challenge it more. You don't have that safe harbor protection. So we tend to stick with that for right now, and it's been beneficial in the last few years. Call frequency, big thing that came out of the rule, the magic 7 and 7, right? So when that became a rule, you had to have a way to track it and to monitor it and to audit to it and to make sure that you were in compliance with it so that you would also get the safe harbor that you were doing it correctly. So all of that had to be worked on. Same thing with technology options. There are safe harbors about how to use emails and texting and even social media with having consent and with opt-outs, but you have to make sure that you've created a program to enhance that. And then of course, the model validation notice. That's the big one that came out for most of us that was really important in terms of initial demand letters were great. And all of us that were collecting for many years before the rule existed, obviously felt we were collecting properly and were. But there was interpretation. There was a lot of ways for the outside world to kind of basically look at it and say, we're not sure if this letter is in compliance with fair debt or the case law that's out there because you drafted it yourself and you have different information here in it than another debt collector might have. So the model validation model validation notice replaced the initial demand letter. So basically everyone was using the same thing. If you follow the rule with what's required in the content, you have a safe harbor. Again, people can go outside of it and it still could be in compliance, but you might get a challenge. And I also understand that there are times people would like to add more information to the model validation notice for all the right reasons. I understand it. But because this rule is here, once we put it into effect and know that we can still do emails and phone calls and subsequent letters to communicate with that consumer, the MVN is just the start of the process for us. It gives them all the details they need. Once that goes out and you've met that requirement, you're in good shape. So you really want to stick to it. And again, I'm happy to say that we have not had letter litigation like we used to in the past, because there's really not a challenge that the consumer bar has been able to bring on the actual format. So the rule is constantly being assessed by the CFPB. Even as they go through their changes, they're constantly looking at surveys and collecting operational data to see how it's been benefiting or not benefiting, right? They want to learn from it too. So they're looking to see, has the rule created more or less disputes with consumers? That's an interesting one, because early on it looked like there was less disputes. Now with AI, which could be its own coffee with Casey topic,
Yeah,
if you want some time.
it really could.
Now with AI and the bots, there's a lot more sort of disputes going into the consumer portal. Again, they may not have any merit, they could be baseless, but they are just kind of putting them out there. So there's sort of been an ebb and flow of the dispute area, and so they're kind of looking at that. The rule where we really focused is, did it create more or less litigation related to the validation notice? We found it created less. So we're happy about that. And then, are consumers better able to identify their debt? That was the other question. They wanted to give these more details about the details of the balance, and then from what date the balance was done, and the current creditor and original creditor, making sure they had all that info in that first document they received. So at this stage, it does appear that most consumers are happy with the information that they're getting. They're not having to dispute as much. Some of it's in that MVN, whereas before they didn't recognize the name if it was a debt buyer, or the balance seemed off because they didn't remember when their last payment was applied. Now, because the MVN breaks it down a little bit more, it gives them a little bit more insight. So they're going to continue to assess this rule and update it and change it as needed, or based on things that are happening in the years to come. So as I said, the rule enhanced fair debt, but these are some of the big topics that came out of it. And these are the big topics that had to be incorporated into what's going to be our next topic, is our compliance management system, right? You needed to make sure you had policies, procedures, standard operating procedures for how to use these new assets that you had, so to speak, for communications under the rule, right? Itemization dates are a great example. That was a new concept. Never was that listed on an initial demand before. Now you have to have it. And there's 5 of them, right? The interesting part about the rule is that you don't have to use them in any specific order. So you and your client can discuss what makes the most sense, whether it's the transaction date or the charge-off date or the last statement date or the last payment date, or the one that we won, which we were very proud, is judgment date, right? That was not in the initial rule, and the industry did a lot of campaigning to say, look, judgment date could be a very good date that a person's going to recognize. So they did include that, which is great, especially as a debt collection law firm. That really works well for us. So you can work with your clients to decide on things of that nature. Same thing with your opt-out options, starting to create those for emails and texting. A lot of people didn't have that in place, so you needed to focus on that. Call frequency, I mentioned already that the rule of 7, you really need to be able to track the calls more. So all of these topics were things that were to enhance our industry and help us to communicate better with the consumer.
We did have one question, Eileen, about the MVN. Is there a timeline for the consumer to dispute the debt once that MVN goes out to them?
That's a great question. That does come from Fair Debt. Actually, what the rule did is the MVN even tells them when their deadline is. So under the rule, it used to be that the consumer had 30 days to dispute. That is still the rule, but oftentimes with the MVN, based on putting it together, mailing, getting it to the person, people will put an end date on there now, as far as the validation date when they can ask for dispute, of up to 35 or 40 days. So 30 days for sure. A lot of us use the 40 days window based on mailing and things of that nature. The important thing to remember there, though, is they have that up to 30 days or whatever date is listed on the MVN for them to do it. But most of us in the industry accept it all the time, right? So that's the law, but for us, we're looking for resolution. So if they had an MVN and they want to dispute or looking for information 2 months later, we usually put it in a cease, respond with validation, and then continue collection efforts. The other thing we need to remind people sometimes is, although they have a deadline, we do not. Our requirements are you either need to send validation or you stop collections. As long as we have stopped collections, that's the protection they're entitled to. We don't have to send it in 30 days, except in a couple of places. I should caveat that in New York, there's a couple of state exceptions there. But in most cases, you don't have to do it within a certain time frame, right? As long as you're not collecting. Sometimes they're thinking you needed to get that to me within 30 days. That's not accurate under the law. But again, it's about resolution, so we try to work together with them. Okay, so our final slide in this area before we flip topics is cumulative effect of conduct. So you've heard me talking about these new ways of communicating. We had letters and calls, now we have emails and texting. So the CFPB is going to look at a cumulative effect of conduct. And what I mean by that is all these multiple ways of communicating, you still have to make sure you're not violating the law. So strict compliance with one area may not mean that you have protection across all areas. So a very easy example is call frequency. You could say, hey, look, yes, I only did 7 calls in the 7 days that I was allowed to do it. My call frequency, I am in compliance. But if the voicemail that you left had false or abusive language in it, then you have a violation in another area. So you can't hang your hat on the fact that, well, our call frequency, we were right in it, we were proper. No, you have potentially a violation somewhere else. Same thing with call frequency, that you have the fact to call 7 times within 7 days, right? But if you take your 7 calls and do it in a half hour the first day, one after the other, constantly ringing the phone, guess what? It may look like frequency compliance, but it's not, because obviously that is causing the phone to ring and ring and ring and may be deemed harassment. So they're going to look at it as a whole when it comes to communication to the consumer. Okay, so now we're going to go to our second topic, compliance management systems. This should not be a surprise to anybody. A CMS is something the CFPB expects by any entity that it is supervising. And as I already mentioned, we are a supervised entity. You want it to be adaptable to your business strategy and operation. You really want it to always remain in compliance, so it has to be fluid. You have to be willing to update it as you go. And it's very much focused on structure to mitigate harm of the consumer. And I want to bring this point up because, again, since the rule's been implemented, we've had a pandemic. Luckily, that's starting to be much more in the rearview mirror, but there are residual effects from that, right? So one of the examples I can give you is you may have a CMS, especially in our world, that says once you have a valid judgment in a state that allows a wage garnishment and you've done all your other attempts, one of the post-recovery opportunities is to do a wage garnishment. So maybe there would be a certain pattern in terms of that account when it would get moved to wage garnishment status. When the pandemic came out, clients, courts, were constantly saying, including AG offices, governor offices, were saying, wait a minute, hold up. We don't want you using that. We know it's a legal tool, but here's what's going on. We're giving money that's exempt from that. People are not able to get to work. We want to pull that back. And so those became rules that you had to incorporate quickly into your CMS. So something that used to be proper was no longer going to be proper. So you had to stop that pattern. Otherwise, it could cause you to have a potential issue. So we were able to do that. We always had hardship and deferments as a reason for not moving forward. So obviously the pandemic was easy to add to that type of a process. And for those of us that were in the industry, many of us just from common sense knew to take a beat when it came to that, not just having to be told by entities out there doing it. But the reality is that you're always trying to mitigate the harm from the consumer. That's the point of it. Next slide. Your key components. This is what it looks like. A CMS must have board and management oversight. That is essential. Your management must know about your compliance program. It can't be done in one area and another area not aware of it. You want it from the top down to be aware and to be educated to. You want to create that compliance program. So you have policies and procedures that you've developed over time. You want to train to it, and you want to do monitoring of it. So the point is that many of us had a compliance management system before, but you had to do a written, formal, codified version of it. So you did that. You created the policies, then you trained to the policies, then you implemented the policies. Well, now you have to audit the policies to make sure that they're working. You also wanted a consumer complaint process. The CFPB was very focused on that. I remember long ago, it was great. Every month when a client would say, did you have any consumer complaints? And you were so proud to say, no, we've had no consumer complaints this month. Now they question that. They say, now, wait a minute, are you sure there's been no one complaining? Because as we know, a consumer complaint is dissatisfaction. It's a perception. So it could be without merit. It could be baseless. It could be an education issue. It may not be a valid complaint, but it's their perception. So you have to track those both verbally and in writing. And of course, a vendor management program. I've mentioned we're a vendor, so of course we're going to have to be focused on that oversight for ourselves for serving our clients, and then the vendors we use for those clients. Next. So this is just a reminder. You got to look at your policies and procedures, make sure they're covering the regulatory requirements, absolutely submit to management for final approval, review them on an annual basis, of course, because once you put it in place, you can't just leave it and assume it's still fine. And then you want to ensure that they are centralized and accessible to all of your employees, that everyone's aware of them. How do you create these procedures, right? So fair debt always had a bona fide error, unintentional error. If you have policies and procedures to avoid it, you could avoid liability. Well, where do you get the procedures from? Well, it comes from the law. They're not written out specifically for you, but you have to make them up in terms of understanding what those laws are guiding you for. So you look at fair debt and the federal and state and case laws that have come out. As we said, the statute's from 1977. There's been case law since then that guides us quite a bit. The CFPB manual, the consent orders can give you a lot of guidance. During the pandemic, we saw that coming from governor orders and courts. And of course, the AG offices now are acting a little bit like little mini CFPBs, right? So all of the things that they're giving guidance on can be incorporated into best practice procedures. Monitor, I've mentioned this several times already, you have to make sure that your policy is working. You want to make sure that you're creating schedules to do internal audit for those policies and procedures. If you have an opportunity to quality monitoring on calls, for example, like call calibrations, that's really good. You want to make sure that if there is corrective action needed, you update your tools and systems from what you've learned when you've overseen them. Consumer complaint process, again, is a reminder. Our metrics here is that who's responsible for overseeing it, the timeline to get it responded to, analyzing those complaints, escalating those complaints when necessary, and making sure you are responsive. Even if the file's closed here, if something comes into the CFPB portal, we absolutely still need to respond to it.
And right here, we'll break for questions. We're actually got about 4 minutes left. So if anyone has any questions before we have Eileen zip through the last topic for today, please go ahead and put them in the chat now. Oh, and also our poll. Let us know how you've heard about our webinars.
And while they're doing that, I can start off by saying, my next section is going to be why everybody is a member of the compliance department, including Casey. She's a fantastic member of my compliance department. I always tell people that because we have 650 people here. My compliance department has about 24 people in it with law clerks, client audit, client services, onboarding, and compliance. But we are in executive admin, so we are an umbrella to all the other business units. So everybody is a member of the compliance department. They all report to me on a dotted line to ensure that we're doing things properly. So I've had the benefit of Casey helping me quite a bit on different projects and matters over the time as an extension of my compliance department.
And our winner for how they hear about our webinars is word of mouth. So thank you everyone for spreading the word. We appreciate that. And now we'll dive in quickly to our last topic of the day.
Great, happy to do it. And again, as I said, compliance is everybody's responsibility. Everyone that works at your company needs to be a part of it. And so you have to have internal controls for these areas. So making sure you have management structure and organization charts so people know who's in charge of what areas, regulatory compliance being overseen, the policies and procedures constantly being looked at and monitored, such as the quality monitoring, as well as the dispute responsibilities and oversight. They may be in different areas, who's working on the SOPs and who's overseeing disputes. That annual policy review is very important. A change management has to be in your structure to make sure that you can implement that. And proof of training. Training to all employees is important because they're all responsible for compliance. So audits can go different ways. You can do them remote or on site. I mean this in terms of a client and a vendor, or even for us, we can audit an office such as Chicago or our Detroit office when we want remotely, or we can also go on site. You want to look at the scope of services that you're auditing to. You want to make sure that they're in compliance with not only your policies and procedures, but also their own. So you want to make sure that you've checked that you have measurable outcomes for overseeing that, and that you implement a schedule to respond. Everyone should be interactive in their responsibility with compliance and ensuring that it's happening properly. When you identify risk, you want to escalate it when it's important. The big thing off of this slide is finding an observation. And what I mean by that is we always want to be proactive, not just reactive. So when you're doing an audit, obviously there can be a finding of something that could be improved upon and that needs to be taken care of because it's not following the protocol. But sometimes you can look at things and say, hey, this is working really well and it's going great, but here's an observation of maybe a better way to do it. Let's possibly think of implementing that. So you want to look at those findings and observations and see how you can enhance your program. You want to fix it. You want to test to confirm that it's fixed if needed. You want to audit the audit if needed. If there's repeated patterns, to look at it maybe in a little shorter time frame, just to make sure that that compliance is always strong in your core programs. Next. Email and texting, just a reminder why everybody is a part of compliance with us. I'm not the only one doing email and texting. So when we put out templates and rules regarding opt-in and opt-outs, you have to make sure everybody's aware of them to follow them. You want to make sure that the consumer has an opportunity to use the communication method that they're allowed to use if it's available. As I said, sometimes it can be expanded where you can have all of it in use. Others may have it limited because certain clients don't want it to be in use. But again, you're looking at the frequency. You're looking at calls, letters, emailing. It can't be so much that it's seen as harassing. It has to be focused on that it's being used in a way to be resolutionary. So that cumulative effect of conduct is going to be looked at, because there's not a count on emails and texting like there is calls now. But looking at it all together does have a view that the CFPB is going to take. So again, making sure that everybody is part of compliance, knowing whether it's a full cease or an opt-out of a specific communication channel has been new to us in the last few years, right? People used to cease completely, right? Well, stopping letters and calls. Well, now what we're finding is if you're asking the right questions, it's not a full cease. It's just, I don't want calls, but I'll take letters and emails, or I only want calls, please don't email me. This type of communication allows them to control the time and place and media through which they're communicating with us, and that's really important to try to get to that resolution. If they do choose to opt out, you have to respect it. You can't try to get them to come back. That's for them to do. So once they opt out, you can acknowledge it, but that's it unless they undo it. But otherwise, trying to make sure that you're using the communication channels they want to use is going to be very important. And that brings us to our final slide. As I mentioned earlier, we are constantly updating our CMS. The audit piece is critical to make sure that it's always successful. We're always creating new system fields and flags and status codes. We're updating our training all the time so that we're doing it not only with our consumer clients as well as other clients. We're doing it with our vendors, we're doing it with our staff, and we're always developing new audit checklists as well to make sure that the CMS is doing what it needs to do and is following what this rule has brought to us in the last 5 years and what we think it's going to do in the years to come.
Well, thank you so much, Eileen. That was a lot of great information today. Just for everyone out there, here's all of the firm's social media accounts if you'd like to follow us. And the last slide for today has our contact information. If you have any additional questions you'd like, please feel free to reach out to us. And as a reminder, there'll be a survey that pops up on your screen now. Please complete and let us know what you thought today and if you have any ideas for any future topics. And please stay tuned for details on the next episode. Thank you guys all so much for joining, and have a great day.
Thank you very much. Thanks, Casey. Have a great day, everyone.
Yes, thank you.
Go Cavs.